Hi, everyone. Thank you so much for joining us today for our first Research Bites of 2025. My name is Annika Dalal, and I am the Assistant Director for Communications at the Center for the Study of Race, Politics, and Culture. Our monthly Research Bites series is one of many programs that we've initiated to engage scholars, students, staff, and community members in interdisciplinary scholarship and programming around the topics of race and ethnicity. Thank you to Tiara, our center's program administrator, for thinking up and bringing to life this series. And thank you to Taylor Pate, our multimedia and marketing assistant, excuse me, sorry, for her work behind the scenes. Our goal for this series is to connect staff from across the university with faculty affiliates of the center who study, teach, and write about race and ethnicity. We wanted to create an informal and interactive space where staff can learn firsthand about some of the exciting research happening on campus and to provide an opportunity for faculty and staff to network and eventually collaborate with each other. You can subscribe to our Research Bites and CSRPC listservs to be notified of future conversations. If you are a student, we hope you took advantage of tuning in live for the in-person student lunch with our partners at the Office of Multicultural Student Affairs. Unfortunately, the center cannot offer lunch on us due to university-wide budget cuts, but we hope this will change in the future. And today we are joined by a very special guest, Assistant Professor of Law at the University of Chicago Law School, Adam Davidson. Professor Davidson is an assistant professor of law at the law school. He researches and teaches primarily in the areas of criminal law and procedure, constitutional law, and the intersection of race and law. His research broadly focuses on how tools within these and other areas of the law can further the debate about reforming or abolishing police, prisons, and the prison industrial complex. His work has appeared or is forthcoming in the Columbia Law Review, the Michigan Law Review, the University of Chicago Law Review, the Washington University Law Review, and the North Carolina Law Review. So with that, we'd like to give a warm welcome to Professor Adam Davidson.
Hi, everybody. Thank you so much for inviting me to give this presentation. So like it said in the chat, uh, please feel free to interrupt literally at any moment. The honest truth is that I watched some of these to sort of prepare, see sort of what the expectations were, and I realized that law does presentations incredibly differently, where it's like we get up and especially at the law school here, we'll talk for maybe 5 minutes, and then we'll just be peppered with questions about a paper or ideas or whatever. And so genuinely from the moment I start talking, which is a couple seconds ago, feel free to just start asking me questions about anything that I might happen to say. Um, with that, I did try to prepare some slides. I'm not very good at PowerPoint. Uh, Please forgive me for the basicness of this, but I figured I would start with sort of how I got into the academy, because I didn't really plan to be an academic when I came to law school. And that I think will take me into sort of the research that I do today. So I'm going to share my screen. That's over here. Okay, so I came to law school having spent most of my high school, well, all of my high school and college life, and the next several years thinking that I was going to be in theater. I did an undergrad degree in theater from the Ohio State University. Thought I was going to do musical theater, studied musical theater, in over the summers, spent a summer in New York, all that sort of stuff. Did experimental theater, and then kind of randomly, it was an election year. It would have been 2012, I guess. And I just kind of started getting interested in what is election law? How does this whole process work where we pick, the leader of the country? And I just started reading law review articles. And it just was fascinating to me reading about not only election law, but how things like partisan gerrymandering work and all those sorts of things. So I came into law school having had that sort of intellectual experience, but knowing that the reason I really wanted to go was because uh, at my core, I've always been interested in issues of race, racism, racial hierarchy, and some sort of interaction with the criminal legal system. Because I think if you study race for any period of time, you very quickly see how those things intersect. I've always been a pretty practical person. So I figured I would go to law school and I would be a progressive prosecutor. Okay, and you might think, why on earth would you decide to study race and criminal law and think, you know what I want to do? I want to throw people in jail. Uh, that's a good question. And it actually just kind of came down to this guy on my left, Eric Holder. And what I realized was that if you could get into these sort of policy making positions, you could be wildly decarceral. And here's what I mean by that. Prosecutors have a lot of power, and that power is legally often totally unreviewable. And so the things that a defense attorney, a public defender might fight for hours or weeks or months or years to do, a prosecutor can just kind of decide to do it. And so when I looked at, what Eric Holder was doing at the Department of Justice at that time, I realized like, wow, he has gotten thousands of people out of prison, tens of thousands actually, through the policies that he was implementing as a prosecutor. And so I thought, okay, that's a great way to use access to power for decarceral, potentially racially equitable ends. And so my first internship was at a prosecutor's office, was at ED&Y, the Eastern District of New York, which covers Brooklyn and a bunch of the airports. Uh, and at first, I kind of liked the gig. Like it's really interesting. Like it's interesting work, it's legally complex work. It, scratches that intellectual itch. But then we took what I will colloquially call a field trip. And we went to the federal prison in Brooklyn, the MDC. And in there, we saw the solitary confinement wing. And solitary confinement, this isn't actually an effective picture of it, but solitary confinement uh, involves putting another human being in a cell for about 23 hours a day. And that cell is less than the size of a parking space. The other hour is outside time, and I put outside in quotes because it's not really outside often. It's basically a dog kennel that maybe lets sunlight in, where you have some more space to move around. Uh, and I realized that I didn't know if I could do that. I didn't know if I could put someone in there through my choices, no matter what the sort of big picture goal was. Something about that felt wrong, sort of in my morals, in my spirit, in my soul, whatever you want to sort of call it. But then something else happened. To the extent I was on the fence after that, it was when I went to go see uh, a jury return a verdict in a drug trafficking case. So I mentioned that this prosecutor's office covers the airports, and so you get a lot of drug courier cases where people try and sneak drugs in through JFK Airport. And this was one of those cases. The thing about those drug courier cases is that they're often people who have no other criminal involvement. Like they're not people who, do violence against others or other sorts of things. Um, in this case in particular was a 19-year-old Black woman who was a college student, had never been in trouble with the law, and she said that her boyfriend back in Jamaica must have snuck the drugs into her suitcase. It wasn't that much drugs, and so that's a somewhat plausible story. But the jury didn't believe her, and so they convicted her. And when the jury came back and read the guilty verdict, it broke her. Like she was crying and wailing and like running around the courtroom. And I was kind of worried that the marshals were going to restrain her. But it wasn't just that, it was her family and friends who were in the courtroom too. And it clearly broke them too. And it just really hit home that whatever harm that the drugs that she brought into the country were going to do to her community, this prosecution had also done harm to her community. And, I still remember being in the elevator on the way back to the office with my supervisor at the time. And he asked me like, oh, are you, that was rough. Are you okay? And I'm just like, oh yeah, no, I'm okay. But, internally, I realized like this isn't what I can do. I can't do this. This isn't the part of the system that I can be involved in. And so then I left that internship not really knowing what I was going to do. I figured, I'll do the thing that a lot of my now students do, which is they go to a big law firm, they make a bunch of money, they work really hard for a few years, and then they sort of figure it out. Um, but then when I came back to school, I was very fortunate to be part of the first class of critical race theory that was taught at the University of Chicago Law School. It's taught by a visitor. She's now a professor at Colorado. Her name is Ray Rothmeyer. And it really felt like I found a potential intellectual home. Those of you who don't know, the University of Chicago Law School has a long history of law and economics, of sort of economic thinking being imported into the legal sphere, especially, torts, crime, whatever it may be. Um, and you learn a lot of that in your first year as a law student here, and it didn't connect with me. It didn't connect with me, I realize now, in part because that is a way of thinking that discounts a lot of the things that I care about and that the people I care about, and can't quantify those things, and so sort of puts them off to the side. And critical race theory sort of showed me that that wasn't the only way of thinking about law. It's a way of thinking about the law. Sometimes it's a helpful way, but it's not the only way. And so when I took that class, I thought, oh wow, maybe I actually can do this academic thing. This feels like an academic endeavor that I might actually enjoy and I might be able to contribute to. And then two other things happened. I had the great fortune of working on two pretty important cases that happened in the Chicago area, in Illinois, and nationally, honestly. One of those was called the fake stash house cases. So in those, the Bureau of Alcohol, Tobacco, and Firearms would go up to people, usually Black, and say, hey, uh, we know about a fake stash house. We know about a stash house. A stash house is going to have a bunch of drugs in it, and it's going to be the easiest money you'll ever make in your life. Uh, and they would prod these people and say, hey, bring some friends along. Can't just be you. And bring a gun too. Uh, and of course, these stash houses didn't exist. But uh, because they didn't exist, the ATF could say that the amount of drugs was enough to trigger a mandatory minimum prison sentence. And by getting people to bring a gun, literally any gun, sometimes a non-functioning gun, uh, there was one case where it seemed like the gun was like from the early 1900s sort of thing. Uh, they managed to uh, basically try to coerce people into decade plus long prison sentences as a mandatory minimum. And one of the clinics here, the Federal Criminal Justice Clinic, was sort of tipped off to how this was working and how it had worked across the country, and how it was being imported into the Northern District of Illinois, which covers Chicago. Uh, and we started looking at those cases and we realized, wow, this looks like racial targeting. And racial targeting is illegal, uh, but it's also the sort of illegal that's incredibly hard to prove. And because of that, you can kind of get away with it if you're the government. But we had such strong evidence, and thankfully we had a really great expert, that we thought we could prove it up. And it scared the prosecutor's office enough, and the judges in the district got curious enough about it that 8 district court judges decided to hold a single hearing about these dueling expert reports. And even though they said, well, we can't dismiss the indictment, the opinion that came out said this harkens back to some of the worst parts of our history in this country, and it's a law enforcement tool that really needs to end. So in the end, what ends up happening is every mandatory minimum sentence got dropped, and the prosecutor's office here offered basically the most lenient plea bargains that we could have possibly imagined. And most of our clients got either time served or no prison time if they'd, been out pending trial. The other thing that I got to work on was the ACLU's consent decree against the CPD for their use of stop and frisk. And that both gave me a lot of hope because what happened, for the people who don't know, after that lawsuit was filed and that consent decree sort of came into force, CPD seemingly stopped using stop and frisk. Like they dropped by like 80% in a year. And so that gave me a lot of hope about the power of law. But then we got more data, and it seems like they just replaced those sort of street stops with similarly racially disproportionate traffic stops. And so I graduated with this sort of ambivalence about the power of law to really do good. And what I did after I graduated was I did something called clerking. So I worked for these 3 federal judges, in fact, Judge James Gwynn, now former Judge Diane Wood, and Judge Guido Calabresi. Um, and what clerking means is that you are one of 3 or 4 recent law graduates in chambers with the judge, and you're helping them decide cases. You're prepping them for arguments and for trials, and you're actually often writing the first drafts of the opinions that they issue. And so it's a really amazing experience. My 3 judges were 3 of the best people I ever got to work for. The 3 people who deeply care about justice and the law and the rule of law. Um, uh, it's Judge Wood is now my colleague and was my 1L teacher as well. And I spent those 3 years. I spent those 3 years uh, thinking about criminal law, thinking about race. And one thing that kind of constantly came up in my mind was the 13th Amendment. The 13th Amendment says that neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Now, most people know that amendment without that sort of clause in the middle of it. They know that the 13th Amendment got rid of slavery and involuntary servitude. It ended chattel slavery. The North wins. We have Juneteenth as a national holiday. Awesome. Uh, but I knew about this sort of except clause in the middle of this thing. And I spent 3 years waiting for it to come up, right? We did lots of criminal cases, lots of trials, plea bargaining, sentencings. Uh, Judge Gwynn even like has a special interest in sentencing and sort of polls the community every time there's a trial to try and calibrate his sentencing to what the community actually thinks. Uh, and in 3 years, this was never mentioned. And I just kind of thought, well, that's really weird. Uh, And so that brought me to the accept clause when I was a professor. And I figured I would write this paper that would be like, well, okay, right now we're not really taking this seriously. In sentencing, we have these sentencing factors, what sentencing is supposed to be, what it's supposed to say. Um, but what would it like to take this seriously and to apply those factors when we're thinking about seriously punishing someone uh, to either slavery or involuntary servitude? And so I figured that a bunch of people would have written on this in the academy. There'd be a bunch of stuff out there, and then I'd be able to focus on this little sentencing part. But it turns out that though there is some historical work, some really great work by Professor Michelle Goodwin, Professor Jim Vander up at Rutgers, uh, Andrea Armstrong, have all done work in this area. No one had actually just tried to figure out, well, wait a second, why don't we talk about this like punishment? Like when we punish someone, there's a bunch of things that are supposed to happen, uh, but none of them seem to happen when we impose this punishment. And so that led me to this paper called Administrative Enslavement. And so what is administrative enslavement? That's this systemic, you can read the quote. Um, basically, administrative enslavement is we don't treat the punishment of enslavement like a punishment. We treat it like a piece of prison administration. And courts don't really dig into prison administration. They think that's a thing for the bureaucrats over there, for the wardens, for the guards. We don't really know how to run a prison, and so we're going to very, very heavily defer to them. And now they're just saying, well, actually, this slavery involuntary servitude thing, that's part of that. We leave that totally up to the guards and we don't really review it. We don't think about it in terms of, well, wait a second. When we sentence someone for a crime, we think about what's the proportionate punishment? What's the punishment that's appropriate for this individual who committed this crime, who did this act? Instead, they just say, that's not our business. And so I think there's the way to think about this is to think about how criminal prosecution and how civil rights litigation works. And I'm also going to try and look at the chat because perfect. So yeah, so I think the way to think about this is to think about, okay, how does criminal prosecution work and how does civil rights litigation work? And in the end, why does none of it seem to apply to the 13th Amendment? So the first thing to realize is that if you are charged with a crime, there are certain things that your lawyer has to tell you. Ultimately, you are in control of your case. So if you don't want to take a plea, your lawyer can't force you to. If you want to testify, uh, your lawyer can't prevent you from doing that. Same with if you don't want to testify. That's ultimately your choice. Uh, and so your attorney has to tell you certain things during sort of the pendency of the litigation. They have to tell you sort of what are the charges against you. They have to explain what that is. They have to explain to you what your punishment is, what the potential punishments are. If they get an offer for a plea agreement from the prosecutor, they have to tell you about that so that you can decide whether to take it or not. They also have to tell you about certain things like immigration consequences. So if you taking a plea or being convicted of a certain crime is going to lead to your deportation, they have to inform you of that. But then the judge also has to tell you certain things at different points in the litigation. So if you take a plea, a judge is supposed to make sure that that plea is voluntary and knowing, meaning that no one is coercing you to take it, either your attorney, your prosecutor, or someone outside, but also that it's knowing, that you know that you're giving up a bunch of rights by accepting a plea agreement. Uh, and it turns out that lawyers aren't mentioning that part of your punishment is either slavery and voluntary servitude. Judges aren't mentioning either when they accept a plea or when they sentence someone that part of the punishment they're imposing is this loss of 13th Amendment rights, that you're now falling into this exception that allows the prison to force you to work. And It's odd that this happens because there are so many criminal prosecutions every day in this country. And it's been working this way, as far as I can tell, since the end of like convict leasing, when we would sentence people to hard labor explicitly. And so this is especially weird because you would expect to see once someone has been sentenced and not been told, hey, you've lost some 13th Amendment rights, or you're falling within this exception now. You'd expect them to litigate that from prison. People who are incarcerated file lots of lawsuits. Congress views this, or has historically viewed this, as a huge problem and has limited the ability of incarcerated people to file lawsuits. Uh, and so you'd think this would also be something that they might be suing about. And you'd be right. There are cases where people go to the federal courts, say, hey, my 13th Amendment rights are being violated. This prison warden, this guard is saying that if I don't work, they're going to punish me in a variety of ways, usually through sentencing them to, through sending them to solitary confinement. And the courts overwhelmingly say, too bad. Not even with a lot of explanation. They just point to this. They say, well, the 13th Amendment has this clause in it that says you can be punished to slavery and voluntary servitude when you've been convicted of a crime. And that means you have no claim. Goodbye. And that's strange to me. That's strange to me because there's a whole bunch of different ways uh, that you might think that's limited. So you might think if you're not told that that's part of your punishment, it shouldn't be part of your punishment. The court says, no, that's not how that works. You might think, well, okay, uh, surely, yes, maybe I can be punished. But if it's just the state trying to save money, then that's not really a punishment, right? The court says, no, that's not how that works. You might think, well, okay, maybe I can be forced to work for the state. But if I'm then forced to work for some private company, surely that's different, right? And the court says, no, that's not how that works. Over and over again, the courts just point to this language or point to older cases that point to this language and say, nope, there's no problem here. There's no constitutional problem whatsoever. And why does this happen? I think most of the reason this happens is because these are pro se incarcerated litigants. So what does that mean? That means that someone is currently in jail or prison, and they are not represented by a lawyer. Usually, this means that they are handwriting their complaint. They have limited access to legal materials, so there's not an easy way for them to look up relevant cases or statutes or to get legal advice. It also uh, comes with all of the failings of the education systems that lead people into prisons. And so these aren't particularly well-written complaints. They're not short. They're not focused. And so I can tell you from having tried to decide or help a judge decide some of these pro se complaints, it's really hard, even if you have the best of intentions, right? You're trying to deal with someone who is in an incredibly hellish atmosphere, draft a legal argument when they have little to no legal training, and you're trying to figure out, okay, what's happening? Like, what can I actually do for them, if anything? Does the law actually say anything about this? And so, in the best of times, uh, that's a difficult task for a judge. In the worst of times, judges don't care. They just sort of shunt it off to the side as a thing that they've got to deal with, and they're going to deal with as quickly as possible so they can get to their other more complicated, maybe in their mind, more important cases. And so if you see a pro se incarcerated person being said, well, I'm being forced to work, it's an easy out to just be able to point to the 13th Amendment and say, oh, there's text here that says that that's fine. But that ignores all of the complexity that a lawyer or a legal group like the ACLU, like the NAACP, would raise in bringing all of these claims. And so over 50 years, the law just develops in this way over and over and over. And all of a sudden, we get to the 90s to the 2000s, and courts can just cite 10, 20 other cases saying that, well, this is how the law is settled, and they don't have to think about it anymore. And so, as I was trying to figure out that problem, I realized that that is true in the federal courts. And it was true in the state courts too. But it wasn't totally true in the states generally. What it ended up happening is that people realized, okay, we probably can't change the federal constitution. And the courts aren't really that helpful here. But what we can do is maybe we can change state constitutions. And so to explain how this works, I think there's two basic legal ideas that I need to mention. The first is that the federal constitution contains something called the Supremacy Clause. That clause makes federal law take precedence over state law. So if federal law and state law conflict, federal law wins. But the federal government has limited powers. It only has the powers that the Constitution gives it. And all of the other sort of reserve powers still lie with the states or with the people. So that means that the states can make laws to regulate in ways that the federal government just can't. But more importantly here, the federal constitution sets a floor for the rights that people have. And state law and state constitutions can give people more rights above that floor, even though they can't go below it. And that means that if you change state constitutions, you can give people more rights in the 13th Amendment context. You can say, as a matter of state law, there's no exception here. There's no exception for punishment for punishment of a crime to slavery and involuntary servitude. We're just banning it entirely. And in 2018, Colorado was the first state to pass a constitutional amendment saying exactly that. Their constitution now just reads, there shall never be in this state either slavery or involuntary servitude. In the last 6 years, more and more states have joined them. Even last year, Nevada altered their state constitution to say something very similar to what Alabama, Nebraska, and Vermont now say, which is that slavery and involuntary servitude are prohibited, period, no exceptions. Other states have also altered their state constitutions to ban slavery and involuntary servitude. But they've done it in sort of weird ways. Like these earlier states, or these states here, just did it by saying there will never be slavery or involuntary servitude in this state. But other states wanted to sort of preserve things that they worried a total ban might get rid of. So Oregon says, there shall be neither slavery nor involuntary servitude in this state. But upon conviction of a crime, Oregon courts can do certain things like mandate education, counseling, treatment, community service, alternatives to incarceration. The reason they do this is because there was an argument around the time that the 13th Amendment was passed that, well, wait a second. If slavery is really about a lack of freedom, then why isn't incarcerating someone in a prison just slavery? And so one way that historians have argued that the Republicans who passed the 13th Amendment meant to have that exception was to say, well, we're not getting rid of prison entirely. Unfortunately, the opposition to the 13th Amendment's interpretation won, and we have the sort of broad interpretation that I've described. But what you see in these states is, what you see in the states now is this desire to preserve the ability to mandate people do some things, but those things will hopefully be rehabilitative and not punitive. But it does raise the last question that I'll discuss today, which is what is slavery? What is involuntary servitude? And really, what's next? Calvin Duncan is a man who spent 28 years at Angola State Penitentiary in Louisiana, uh, and then was exonerated. He didn't commit the crime. And Angola is infamous in no small part because it just was a slave plantation. And if you go there now, you will still see mostly Black men working under mostly white men armed on horses in the same fields. Turns out that basically everyone who is sent to Angola prison has to spend at least 90 days in the field. That 90 days can be extended at the whim of the guards. But even if you're able to escape, you can still be forced to work. Most work now is intra-prison, right? It's not for private companies. It is helping the state save money by not having to hire people that it has to pay, that it has to provide job protections for, that has to provide health insurance for. Uh, it's just incarcerated people that they can force to work for little to no money. I think one figure I saw was that it was 2017, the average pay rate was about 14 cents an hour. And so when Calvin Duncan was interviewed about his experience at Angola, this is what he said. The people say this is modern day slavery. This ain't no modern day slavery. This shit is slavery. And that's the question that the courts, that legislatures, that organizers are now going to be forced to deal with. When we say we're banning slavery, when we say we're banning involuntary servitude, what does that mean? What are we saying that the state can't do anymore, that no one can do anymore? Is it just, well, we can't physically force you to work? Or does it mean something more than that? Is there something about the coercion inherent in the prison context, in the jail context, that means, well, if we want people to work, and it turns out that incarcerated people often want to do productive work, what does it mean for that to be voluntary? Do we have to rethink how we're incarcerating people more broadly? Or is it something much smaller? We just have to put in the statute that all work is voluntary, and that makes it fine. And so I think that's the big question that I'll leave you with at the end of this talk. Uh, what is it that if we say we're going to change the law, if we say we're going to be a society where there is no slavery and there's no involuntary servitude, what does that mean? Thank you.
If you guys have any questions, you can come off mute and ask your questions or raise your hand, or you can drop questions in the chat.
Thank you so much for that presentation, Adam. It was really, really great and learning more about your work. I actually had the pleasure of meeting Calvin Duncan. Um, I don't know, maybe it was like 5 years ago. He led a tour, quote unquote, of Angola prison, him and Norris Henderson. And it was, I mean, literally when we drove onto the prison grounds, the first thing that we saw was people working the fields. And it just, to say, oh, there's no slave plantations anymore. We saw that. And then Calvin and Norris continued to tell us the amount of money, right? The cents that
Mhm.
people people made an hour. And they also shared with us that I think maybe it's the first year people don't even have access to the money, right? Because the prison is telling them, you need to save your money. So this pittance that they actually do get, they can't even use towards commissary or anything like that. So anyway, thank you for sharing that. I am wondering if you could share a little bit more about what are the current battles to abolish like indentured servitude
Mhm.
or the kind of slave labor that's happening in the US right now in our prisons. If you could talk a little bit about that.
Yeah, so I mean, I think this is the big movement. People have realized that state constitutions are much more amendable than the federal constitution, but even than often federal law. And importantly, a lot of them are amendable in ways that don't necessarily require you to work through the legislature. And so through a combination of legislative wins and sort of organizing, petition collecting, uh, I think it's 10 or 11 states now have these amendments. And so the big question is, well, okay, what do we do with them? And so there's a case that is, as far as I can tell, the furthest along in the country in Colorado. It just got class certification, which means that it's no longer just about, the two or three named plaintiffs. It's about every incarcerated person in Colorado. And the judge there has said that the Colorado Department of Corrections does have to make some pretty material changes to its work programs. So uh, it can't importantly use solitary confinement as an inducement to work anymore. Um, there were also and around the country, there are allegations that physical force is used to make people to work. And the court said you can't do that anymore. Unclear whether you could have done that before. Like that might just violate the Eighth Amendment prohibition on cruel and unusual punishment. And so on the legal front, sort of that's the big thing for like lawyers, people who are sort of legally oriented to get involved in. Uh, but there's so much organizing happening on the legislative front, on the ground. There's an organization called End the Exception, which is helping to coordinate a lot of this nationally. Um, there's some people actually that I have to reach out to at NYU who are doing this, sort of from the academic book. I actually have their book right here, Abolition Labor. You can see that. That's really amazing work. They interviewed a lot of incarcerated and formerly incarcerated people to really dig into sort of what is happening on the ground. Um, and I, this is, probably the thing that I'm going to try and start figuring out next is Illinois hasn't really had much, if any, movement on this front. And I'm not sure why. Uh, because it seems like a state that would be primed to have this sort of change. And so that's one thing that I personally want to start digging into and start sort of reaching out to people to figure out if there's any sort of way to make some movement there. I see someone put in the chat. What studies and data points as to how much money states make off of this 13th Amendment exception? Are there arguments that can be built to demonstrate that both states and the federal government are so focused on monetizing this exception that this demonstrates that it's not about appropriate punishment, but just about the dollars? So there's a recent cost-benefit analysis done on this issue nationally, and they said that if you were to pay incarcerated people a fair wage, I think it was somewhere between 12 and $18 billion a year. California voted on one of these amendments last year, and it didn't pass, sort of surprising everyone involved. But California had also had that was actually the second time the amendment failed. The first time it failed because uh, the argument was made that passing the amendment meant paying incarcerated people California's minimum wage. And I believe the number that was brought up there was 1.5 or $2 billion per year just to pay minimum wage. And so we are talking about billions of dollars in state funds or state savings. Um, not to mention, uh, not to mention any goods that are produced. So a lot of there's a history here of union labor sort of pushing back on incarcerated labor because incarcerated labor was used and was threatened to be used as a strike breaking force, right? If you can force people to work and they don't have the power to unionize, you can use them to break a strike. And so one thing we see around the rise of unionization in the early 20th century are a bunch of laws that say that incarcerated people or goods produced by incarcerated people, can't be in the market. They can only be sold to like other government entities. And so you do have this weird situation now where like what is it? It's the 11th Circuit, which is down south. So like all the furniture in the courthouse is made by incarcerated people. You see that in a bunch of different sort of government entities where incarcerated people are making stuff and it can only be used by the government. But that's not, nationwide 100% prohibition. And so there's also the problem of incarcerated people making goods that are being sold for profit that they are not seeing. Um, I think to the extent that there's a problem with arguing that it's just about the dollars, uh, it is difficult to overstate how vast and expensive our criminal legal apparatus is. And so even a figure like, at the high end, let's call it $20 billion, is nationally a drop in the bucket. And so I think there's an argument to be made in some places, certainly in some prisons, that it really is about the money. Nationally, I think that's a harder argument to make because I think what it's about is the control. Uh, that what's really happening here is that prison wardens will routinely say the thing that they want to fight against is idleness because when people are idle, problems happen. And so being able to force them to work is one way to force them to be busy and is a way to control them, to make them tired, to make sure that they're not doing anything that is either harmful to other incarcerated people, but also that they're not organizing. And so it's a great way to ensure that the prison continues to have total control over incarcerated people.
Adam, I'm sitting here thinking, like, what is my question? And I'm not really sure, but I'll just sort of spew out some things, and I'm curious about what you think about them. I too was thinking similar to Maya of kind of thinking through like what are all these driving factors here of control. I think not just control of like what they're doing during the day, but also just this power sense of like this is a
Mhm.
population that needs to be controlled. And so this kind of more existential relationship that oftentimes we see happen between different groups of our society and how we're arranged and positioned within the society. But I also wonder, have there ever been arguments around, what am I trying to, I'm not going to use the right legal term, but just sort of sovereignty of one's own body,
Mm,
and the as a basic human right. You hearing what I'm saying? Like I
yeah.
wonder, like what are the different ways one could go at this to sort of articulate that even if you break the law, are you having to surrender the sovereignty of your own body to any kind of treatment, any kind of way?
Yeah. So I think uh, it's so interesting because uh, there is an infamous, technically repudiated quote from, I think it was pre-Civil War, but I think it was the Massachusetts Supreme Court said that prisoners are slaves of the state.
Mm,
And so there was this long idea that, like I said, technically repudiated, but really sort of what we're doing is saying that if you're incarcerated, you give up you have all of your rights stripped from you. You are under the total control of the state now. And there has been a serious and successful pushback against that. The Warren Court in the 1950s, 60s, really started to set some ground rules to say that, okay, what's happening in our prisons is abhorrent. You actually see some judges around that time, or at least one, sort of explicitly say that he thinks prison is going to end, like this institution can't continue. And you start to see, prisoners or incarcerated people gain more and more formal rights. So usually those are through either the Eighth Amendment, so the prohibition on cruel and unusual punishment, or the 14th Amendment, the Due Process Clause, saying that you, at the very least, if some punishment is going to be imposed, there's some process that has to happen before that. But also that, substantive due process says that there's certain things that the state just can't do to you, no matter what process is imposed. And the Eighth Amendment similarly says that there's some punishments that are so abhorrent, so beyond the pale, that we cannot impose them as a matter of constitutional law. And so I think those are really the sort of constitutional levers that would be pushed to say, we still haven't gone far enough. Like, we recognize that people always have some rights, whether they're constitutional, whether we want to call them human rights, whatever it may be. Like, we recognize that there's something there, and clearly what we're doing now, like, violates that. And it's just the question of sort of like, can we, either through the courts or through organizing or through politics, get enough people to see that what's actually happening on the ground violates all of their sort of instincts about what one human being owes to another.
Yeah, which I suppose gets back to how are some groups of people not even seen as human beings, and so that sometimes is still sort of a residue that I think folks come to this question with. Yeah, thank you.
All right. Well, that was an amazing talk. Thank you so much, Professor Davidson. This recording will be will be available on our YouTube channel if anybody wants to check it out later or share with a friend, because I feel like there was a lot of important information given today. Yeah, but that's the end of our talk for today, and I hope you guys have a wonderful day. Thank you so much, Mr. Davidson, for showing up today for our first Research Bites of the year.
Thank you for the invitation. It's been a pleasure.
Have a good one.